state law.
Okay. Thank you, members. Thank you.
Thank you.
Members, any other questions? Lynn Machado, here representing herself to speak for the bill.
Good afternoon. My name is Lynn Machado, and I am the mother of Marlise Munoz. I'm a retired elementary teacher, and I'm here to support House Bill 3183, otherwise known as Marlise's Law. Marlise wore many hats. She was a daughter, wife, mother, niece, and a friend. She was an individual. Our lives were shattered on Tuesday, November 26, 2013, when Marlise suffered a pulmonary embolism. Eric, her husband, found Marlise's body on the floor at their home. Emergency personnel were quickly summoned. Shortly afterwards, my husband and I received a call from Eric. We met at the emergency room at a local hospital in Fort Worth. Hospital personnel brought us to Marlise's bay in the ER. I knew she had died. The attending ER showed us Marlise's CAT scan. It was completely white. Even though Marlise had died, her body was connected to an artificial life machine because she was 4 months pregnant. We were informed about a little-known law in Texas, Chapter 166, that restricted us from removing her body from the machine. We knew what end-of-life wishes Marlise wanted. She had stated them several times to her dad and I, and to her husband Eric. Chapter 166 overrode her wishes. We felt angry, frustrated, and helpless. We felt our hands were bound and tied by the government. We felt the government had overstepped their boundaries. Marlise was not in a coma or unconscious. Our daughter was dead. Yet the hospital continued to stand firm in their misunderstood interpretation of Chapter 166. For 2 months, we watched our daughter's corpse decompose. The smell of death lingered in the room. We, her family, made a vow to, 1, educate the public about this little-known law, and 2, get the law changed. No one should ever have to go through the horror, the tragic, and the macabre experiences from Chapter 166. End-of-life decisions belong between a family and the medical staff, not with interference from the government. This is why our family firmly supports Marlise's Law, House Bill 3183. Thank you for your time and your attention.
Yes, Representative Farmer.
The question I asked earlier, if you feel comfortable answering it, is who paid for the costs of the care? Was that family incurred?
Her husband will answer it when he comes
Thank
up.
you very much.
Yes, you're welcome.
Thank you for being here in honor of your daughter today.
Thank you, and thank you for honoring her with a hearing.
Members, any other questions? Eric Munoz, here representing himself, here to speak for the bill.
Good afternoon, ladies and gentlemen. I am husband of Marlise Munoz. I'm a firefighter paramedic currently for the city of Crowley.
Eric, if you don't mind, just
Go
so
ahead.
we do this exactly right, if you go ahead and state your name, for the record.
Eric Munoz, firefighter paramedic.
Okay, and then you're here
I'm
speaking
here
for the bill.
to support House Bill 3183.
Thank you.
I stand here literally with my hands behind my back, as I did figuratively, back when I was at the stay at the hospital. At that time, I could not do anything for my wife. Literally, could not do anything. She had stated her wishes to myself, my in-laws, and we knew what she wanted. Had such an event happen to her. I asked y'all to consider House Bill 3183 to to avoid any further event happen to any family. I strongly believe that that is a family matter, whatever belief or upbringing you have. I believe that is completely up to the family to decide based on their knowing their family member, their loved one, and their stance on it. And hopefully they have an open discussion about if such a case it happens. Something that unfortunately is not done. Fortunately for me and my wife, we did speak about it in front of her parents. We all were on the same page. I really do ask y'all to consider the bill. By considering this bill, y'all will give families the ability and the medical staff on an individual basis, because I do believe that each circumstance is individual and should be considered as such. I really do ask y'all to consider this bill and give families that opportunity and avoid the pain and suffering that my family, not only here, but my family as far as on my side, family and friends, to avoid that pain and having to endure that long stay and seeing our loved one in a bed, having all these procedures done to them without your consent and not being able to do anything about it. So that is all I have.
Members, any questions? Representative Farrar?
Sir, it's just the same question, and if you feel comfortable paying, answering the question, I was just concerned with as I heard the story in the news, one of the questions in my mind was, if the state is compelling this, who is the state paying for the costs of all of this treatment? I know it's very expensive.
The costs were very expensive. My wife did have insurance. I don't know how much of it the insurance paid, but I do know that there was a portion of it that remained unpaid, and per the hospital, they relayed to me that I would not have to worry about such costs. Now, as far as that goes, I don't know if the state consumed the cost or if the hospital itself, but I did not. Like I said again,
In this case.
as far as that goes.
Maybe for the publicity and such. I
Yeah.
just wonder if in other cases is this, it sounds like in this case it is
And that's another thing that's
the
not.
hospital and the insurance.
Yeah, and that's another thing the current bill doesn't address. I mean, they force somebody to be on life support, but then what about the other issues that arise from such an event?
Right. Thank you.
Yes. Your wife was at John Peter Smith, was?
Yes, sir, she was.
John Peter Smith's county hospital, and so it would have been, the county would have picked up those additional expenses.
Any other questions?
Members, any other questions? Once again, our condolences to you, to your family, and thank you for being here.
Thank y'all. Thank y'all for your time. Y'all have a wonderful day.
Susan Hayes, NARAL Pro-Choice Texas and Self, Legislative Council, here to speak. Bill. We'll show Ms. Booker for the bill, not testifying. Heather Ross, representing herself for the bill. Is Heather Ross here? We'll show her for the bill, not testifying. Blair Cushing, representing herself for the bill.
Good afternoon, representatives. My name is Blair Cushing. I'm here representing myself, and I am testifying in favor of this bill. I'm currently a fourth-year medical student at the UNT Health Science Center in Fort Worth. I've done the majority of my clinical training at the JPS hospital. I was not directly involved in the care of Marlise Munoz, but I have worked closely with many of the providers there. And I do not at all want to imply that I'm speaking on their behalf, but through working with them, and in particular, most recently working on their medical ICU this past fall, with many of the providers who did care for Ms. Munoz, I came to an understanding that many of them did feel that they were unfortunately restrained by the law from utilizing their best medical judgment, from following through on the wishes of the family, and seeing how those same providers cared for other families who were in the situation of having to make end-of-life decisions about their loved one, realizing that they are very respectful of those decisions. And unfortunately, another occurrence that has happened since this case took place is that within the community, I've many times found myself having to defend those wonderful providers who have participated and played such a large role in my training and whom I know to be very compassionate towards their patients, and having to express to others within the community that this is occurring because of the state law. This is not occurring because these providers are uncompassionate or because they disregard the wishes of a family or they disregard the wishes of the patient or that they believe that this is the best thing to do medically speaking. I very vividly recall being at a dinner with one of those providers who also teaches medical ethics and referring to the machinery that Ms. Munoz was hooked up to as life support. And he very quickly and adamantly corrected me that you cannot call that life support when in fact a patient has already been proven to be brain dead and meets the legal definition of already being deceased. So since then I've been very careful about my wordage and how we discuss that. So my personal path is that I intend to pursue training in family medicine, and I'm expected to enter a residency and such in the coming months. And I see it as a tremendous privilege as a future medical provider that I will have the opportunity to have these types of discussions. And once I do have my own panel of patients, very much want to ensure that every single one of them engages with me in discussions about end-of-life care and advanced directives, no matter what their age, no matter what their health status. I'm actually currently doing a facility-based geriatrics rotation where this is a daily occurrence, that I'm looking at people's advanced directives and having conversations with family members about what their wishes are for end-of-life care. And I truly believe that it's one of those things where, as a medical professional, these are one of the most challenging decisions and conversations that we'll ever have, but it's also our ultimate obligation that we do engage in those discussions. I believe that, after you've had these types of discussions with your patients or with their family members, their surrogate decision makers, that it is very much about trust. And I need to know that my patients are going to trust that after they have expressed their wishes to me and even gone so far as to put them in writing in a legal document, that they can trust me as their provider to ultimately carry those out. And if you look at the current language within the advanced directives in Texas, the very first line of that statement says, I, your name, recognize that the best health care is based upon a partnership of trust and communication with my physician. So, although it further goes on to express that there is this exception for, should you be pregnant, that this order is invalidated, I do not believe that many patients would be considering that in advance. And I know for a lot of patients that wouldn't necessarily change their decision. Unfortunately, I feel what does change a lot of patients' decisions is when they haven't had these conversations in advance, and they may very clearly know their own wishes. But then when the time comes, if they have not expressed it to their family members, those wishes become changed when the patient is no longer able to speak for themselves. So, I guess in conclusion, I really believe that as a medical provider, this was a very hard situation to have occurring in my own backyard, at my own training institution, and seeing what these providers were put up against and knowing that in our own medical judgment, this would not have been what we would have chosen to do and the way that we would have chosen to treat this patient or her family. But unfortunately, we were compelled by a state law, which now that we know better, it's high time to make that change and make that amendment. I'd be happy answering questions.
Any questions? Yes, Chairman Garrett.
Ma'am, I'm not really sure how to phrase this, and I'm not trying to be insensitive to the family at all, but when a person is hooked up to machines that are, obviously she was brain dead, but that were, I guess, just keeping the baby alive, what happens, what deterioration has happened to that person's body over a period of months?
Right.
And
So
once again, I'm trying to be sensitive to the family, and I know this is hard, but it's just something that I guess I don't like to know, but I need to know.
right. And in particular, again, not having cared for Ms. Munoz, but just based upon the testimony today and what made it out into the media, that because she was considered clinically brain dead, and because the initial condition that caused her to have ended up in this state was a pulmonary embolism, which means that her lungs were blocked off by a blood clot. So blood is no longer adequately oxygenating and circulating through your body. And that is what provides the nutrients, if you will, to the rest of your system. And in particular, within her case, because she was pregnant, what sustains a fetus is that same blood that's circulating through mom. So for pregnant women, we commonly say that whatever goes into mom goes into baby. So because she was inadequately oxygenated for so long, over time, that's just going to lead to tissue breakdown, essentially. And as was mentioned, it's, for lack of a better term, it's essentially decomposition of Ms. Munoz's body over time.
Thank you, ma'am. Thank you, Mr. Chairman.
Thank you. Members, any, yes, Representative Farrar.
I think there's an assumption that I don't know, speak for my colleagues here, but I'm not a science-based person. I believe in science, but so if you can help me understand, there's an assumption, I think, that among some that the host, that the woman her body would carry this the fetus to term. Is that, I mean, based upon what you were just saying, is that a correct assumption? And is because we do so many things, we hope women take prenatal vitamins, they eat right, they do everything right. Can you?
Right, precisely. So even prior to the ultimate ultrasound that demonstrated the condition of the fetus and that it was most likely no longer a viable life, as a medical student, when this case very first made it into the media, it was very clear to me that this was not going to remain a viable life because of the variety of changes that one's body has to go through in order to sustain a pregnancy. So over time, when a woman is pregnant, there's all kinds of different things that happen in terms of changes in your renal function, your blood volume, your own metabolism. So as a woman's body is no longer able to function for itself, it's not going to be able to grow and change and accommodate to a growing fetus. And so essentially everything's just kind of stopped where it was. And I believe, again, not speaking with any medical record knowledge, but just from what came out in the media, was that there was a growth restriction of the fetus when they did the ultimate ultrasound. And that is what I would have expected just from the very beginning, that someone's body is not going to be able to grow and adapt and accommodate to sustaining a fetus when that body is no longer alive.
In your testimony, Beverly
Thank you.
Knuckles, here representing herself. Dr. Knuckles is against the bill.
Good evening, or afternoon, how about that? I'm Beverly Knuckles, I'm a family doc from New Braunfels, and I've been here before. I am on the board of, and I'm here to speak against this bill. I'm on the board of directors on Texas Alliance for Life. I've represented the Family Medicine section for Christian Medical Association. I'm a member of Texas Medical Association and have done OB as a family doc. Went back and got my ethics master's a few years ago because of these hard questions. This is one of the hard questions. But the answer that we do know is that a woman who comes under this, our
Dr. Knuckles,
Texas
and I
events.
have you here representing yourself.
Yes, sir.
Strictly.
Yes, sir. I couldn't figure out how to separate, so I took the safe way.
Okay.
We know that a patient who comes under our Advanced Directive Act, while she's pregnant, had chosen to be pregnant. And we know that she's alive. In fact, as difficult as it is to say this at the time, all of the time, until Judge Wallace's decree on the 24th, I believe, January, anyway, his decree, no one had actually declared her dead. And perhaps that's where we need to have our discussion, is why that didn't happen. But we know that a woman who comes under our Advanced Directive Act, or a woman who is to be protected
Dr.
by...
Knuckles, let me ask you a question. So are you saying, this committee, that she should have been declared legally dead? Is that what you're saying?
I'm saying that she wasn't. I don't know whether she should have or not. I don't see it would take some days and some serial examinations. We couldn't find out right away. Even though we might make clinical judgments, we still would need to do
So
those
if she'd
serial
been
tests.
declared clinically dead, what would your position be?
if she had been declared dead by brain death criteria, then I would have said that the Texas Advance Directive Act doesn't come into play, and that's exactly what the judge said.
So, and if she had been declared dead, it would be your testimony that the family's wishes could have been honored under that circumstance?
The family, and yes,
Okay, thank you.
yes, sir. I mean, our Texas Advance Directive Act does not override the fact that she had chosen to be pregnant, and as far as we know, she had not changed her mind. We have our Texas Prenatal Protection Act, which in 2003 underlined and stated our Texas law counts life as beginning at conception. So if we are able to diagnose a woman pregnant, yes, sir, Chairman Turner, we would have to say that there is a second legal life in that involved in our decisions.
Yes, Chairman
Yeah, but
Turner.
I want to follow up on what the chairman said, though. Is your position that if she had been declared clinically dead, then the family's wishes should have been adhered to by the hospital?
I'm not a lawyer, but ethically and as a doctor, if she is dead, we may be able to, I would say yes, sir, because as a doctor, we may be able to maintain life's organs for a while, but the homeostasis or the ability to go back to normal of the body systems is going to deteriorate, and I believe that that's possibly what we have heard from. Of course, I didn't examine her. I didn't see anything other than what's in the
No,
media.
let's just talk in a general case. Let's
Yes,
just
sir.
talk general.
If a person is dead, I don't believe the Advanced Directive Act would cover them.
Okay, and that would apply even if she was pregnant for 1 day or pregnant for 3 months, 4 months.
And that is one of those things I'm not certain about. Again, I believe that we would take serial examinations. We would be able to see whether her body is alive, but whether by brain dead criteria, whether or not she's able to maintain her bodily functions with our support. And then that might, again, that might have come under family judgment. But I don't understand how Texas, I'm not a lawyer, and I don't understand how I could handle,
from the purposes
cover her.
For the purposes of crafting this bill, House Bill 3183, from your perspective, you would be supportive of HB 3183 if there was a provision or section in this bill that says if the woman were to be declared clinically dead, then the family's wishes should be adhered to by the hospital.
I don't understand why we would need a law. We can't micromanage everything that far. I don't understand why we would need a law. We already have the judge's ruling saying that it doesn't apply because she was dead.
Right, I got the
And
family.
I would not affect this law or change this law because,
You would force every family to a court of law.
no, sir, I would have preferred that they went through the Advanced Directive 166, where the physicians and the patient disagreed, they would go through that process.
That's the section that kept the hospital from adhering to the family's wishes, and they ended up going to the court, and it was the court that overruled it overrode the hospital's decision. So I'm just trying to see, in order for you to be good with HB 3183, what would you insert?
I would not be, as long as there is life-sustaining treatment, again, I would not be willing, or if she is alive, I would not be willing to remove that life support as long as she's pregnant. We are not stopping any woman from choosing to have an abortion up to 5 months pregnant. We are not preventing her doctor from doing an emergency abortion to save her life if her life is in danger. And there is no provision in the state of Texas for a third party to decide that someone wants an abortion or to choose abortion for a woman.
So are you saying that 166 should not apply if she is determined to be clinically dead? I'm trying to,
And again, I'm not a lawyer, but I don't see how the Advance Directive Act can apply if
I
someone's
know you're
dead.
not a lawyer, but you're sounding like one.
That's that ethics I
I'm
get.
trying to keep the legalese out of it.
Elbow up with all y'all.
I won't act like one if you don't be one. Sound like one. Okay, so I'm trying to understand the essence of your testimony. If a doctors has come to the conclusion and say that she is clinically dead, is it your testimony that then the hospital is allowed to adhere to the family's wishes?
The doctors would be able to dispose of the body the way the family wants them to. Again, though, we're talking about several days, at least a couple of days. So we would be able to tell if she's able to maintain homeostasis. I'm not an expert in this sort of medicine, but I do read a lot. And I do believe that was our problem, was in the determination of whether or not she was legally dead, whether or not the law covered her. And but however, if she's not legally dead and she's still a person under our laws, I think that we still have to follow the Advance Directive Act. And I would not amend it. I do firmly believe that that we should protect every life that we can without from conception.
Dr. Knuckles, but I think if I understood both medical professionals, when they are deemed legally dead, then their bodies are deteriorating. And it seems like
We've gotten really good at maintaining those organs for probably even as long as a month. However, and maybe longer in extraordinary cases, but the homeostasis, the body does not hold together. It does not go back to normal. The liver and the kidneys fall apart.
thank you. Thank you for your testimony.
Function.
Thank you. We're going to call up Tiffany Bishop here, representing herself for the bill. Is Tiffany Bishop